If you look at a global position, as you will see, US, of course, has a national exhaustion and in some cases international exhaustion. Europe has regional exhaustion. Australia has international exhaustion. And India has, as far as trademark concerned, a question mark, which we will discover. As far as a patent is concerned, well, if we read the provision of section 107A, it says importation of patented product by any person from a person who is duly authorized under the law. Earlier it was duly authorized by the patentee. And now under the law, I suppose means the law of the country from where the import is taking place. It can't be Indian law. So if a person is authorized under the law of the country from where the goods are coming, then surely that import is not an infringement. As far as the copyright is concerned, the infringing copy is, if imported, constitute infringement. As you will see, the section 14 of the Copyright Act, it defines copyright to mean exclusive right. And then what is relevant for us is clause I2, to issue copies of the work to the public, not being copies already in circulation. And then there is an explanation which is added to section 14, which defines copyright to say that for purposes of this section, a copy which has been sold once shall be deemed to be copy already in circulation. And there was a debate in terms of copy once sold where? A copy in circulation where? It nowhere says in India. And if it doesn't say in India, then can you say that the Copyright Act envisages national exhaustion? Now, as you will see, section 51 says a copyright is infringed by import of any infringing copies. And as I pointed out, infringing copies is a copy not in circulation. So this doesn't really answer as to whether it's a national or international exhaustion. But if we look at an amendment which was proposed in 2010 of the Copyright Act, it said, in context of what constitutes infringing copy, to say, a copy of the work published in any country outside India, with the permission of the author of the work, and imported from that country into India, and shall not be deemed to be an infringing copy. Now there was a lot of objection to this from various quarters, film producers, software producers, authors, to say that this international exhaustion is going to totally destroy our copyright and our right to commercially exploit different territories. Therefore, this should not be permitted, and this was deleted. Therefore, if we look at the amendment which was proposed and which was dropped, then surely the Copyright Act follows national exhaustion. And these are some of the cases where the courts have held that an unauthorized import is an infringement, and therefore it's a national exhaustion. So you had a case of a penguin which injuncted import of books on the ground. It's an infringement because copyright is territorial in nature, and import will be an infringement. So these are some of the cases which are on the copyright issue which have held. Now, that brings me to my last slide to say, can you assume that there is an international exhaustion? Can you say that the law of international exhaustion can be overcome or is subject to agreements between the parties? So therefore, even if there is an international exhaustion, say in the case of a trademark, let's assume, can I say that, well, I have appointed distributors in India and we have an agreement, or I have a distributor in Germany or US and I have an agreement, and by that agreement I'm defining the territories. And those territories only permit sale of those goods by those distributors in those territories. Now, therefore, those goods, if reach other markets, then international exhaustion will not apply because there's no consent. A consent is essential by the proprietor. I have given no consent. And if so, perhaps the agreements are one of the ways in which you can, and of course there are other strategies that can be followed are endorsement on the products, where you very clearly define the territory and say not for sale beyond such place. Or you have different packaging standards, and you have different localized warranties, so you have legitimate reasons to oppose further dealing in those goods. My comments in terms of the strategies which perhaps are. Thank you very much.